Good afternoon and welcome, everyone. You'll see GoToWebinar's features include a questions drop-down where you can ask any questions you have during the program. We'll collect them all and answer either live during the webinar or afterward by email. Also, please note the orange arrow to the left of the control panel to minimize it, and the handout drop-down where you can download a copy of today's handout. And now we'll proceed with today's webinar, as always, co-sponsored by the University of Florida Levin College of Law Institute for Dispute Resolution. Scott?
Okay, good afternoon, everybody. My name is Scott Schomber. I'm presenting here today with Bo Dennis. By way of background, I was born in Miami, or born and raised in Miami, Florida. I've been a civil trial lawyer for 32 years, practicing primarily in South Florida, but I've also practiced throughout the state of Florida. I've done both plaintiff's work and defense work. Majority of my career has been defense oriented. Had the opportunity to represent corporations, insurance companies, and I did a large stint of in-house counsel work for one of Florida's largest developers and retailers, which gave me an insight as to what the client or what a particular company sees when they enter the mediation process. And it also allowed me to oversee a lot of litigation outside of Florida, so nationwide. And I got to see how mediations were conducted outside the state of Florida, which is quite different than the way we do it here. But for purposes of today, Bo and I are going to primarily focus on, discussing what's happening in Florida mediations. I've been a mediator for 7 years, and during that time, I did primarily as kind of a side hustle, but now doing it full time. And I look forward to chatting with everybody. And hand it over to Bo Dennis.
Scott, thank you very much. Welcome, everybody. First, I want to thank Scott. Scott, this was your idea. I'm going to make sure you get all the credit. Thank you for inviting me to be a presenter today. I also want to thank Kathy Klasny, who's doing all the behind-the-scenes work for us today to make sure that we can hear each other and see each other to the extent we need to. A little bit about my background. I was a civil trial lawyer for 32 years before I became a mediator. Tried over 100 jury trials. I was involved in personal injury primarily, statewide, as well as the main 4 counties down here, down in the Keys, Miami, here in Broward, and up in Palm Beach, a couple of cases in Orlando, and sporadically around the state. I'm approaching 1,000 mediations. I think next week I should have my 1,000th mediation already. And I welcome you all here to this topic. I think it's very germane and interesting, hopefully to you. It will be helpful as far as opening up your minds, and when you go into the other room, think about what people are talking about as an opportunity to maybe get some inroad into settlement. So that's why we're here today, and I welcome everybody, and thank you.
Thanks. And listen, I think Bo's a little generous. It wasn't completely my idea. This all came one day when Bo and I were having dinner and a few drinks, and we're starting to talk about some of the things that go on in the mediations that we conduct. And there was 2 common themes that kept coming up, and those themes really are the title of this webinar. I typically 90% of the time, I'd say I get asked at some point or other, what's going on over there, or what's taking them so, what could they possibly be doing? What are their issues and things of that nature? And I get asked that, and then when I get permission from the other side to share what's going on in their particular room, I'll come in and I'll tell that I'll answer the question. Well, they're dealing with problem X or problem Y, and then the response 90% of the time is, well, that's not my problem. I don't really care. And in reality, if you're going to mediation for the purpose of trying to have some resolution, one side's problem oftentimes and does create issues that make it everybody's problem in the mediation setting to take and reach resolution. If you're not looking to resolve the claim, then yeah, you're right, it's not your problem. But if you're looking to resolve the claim, and I would say the majority of mediations, there is a good faith effort to try to reach some resolution, we all need to be cognizant of what the other room is facing, what issues they have, what pressures they're dealing with. And oftentimes, if we do look at that, we can find collaborative ways to kind of help overcome those pressures and issues and reach a resolution. today we're going to, try to, deal with this topic by, talking about the separate rooms. First, we're going to talk about who's in the room, in each room, and what issues do they, and then the next thing is what issues do they have to deal with? What do they bring to the room? What problems are they facing in the room that you may not be aware of, but they are affecting the mediation? And then we're going to try to find ways that you can plan ahead to try to understand the issues, address them ahead of time, or during the mediation in collaborative methods that they can reach some sort of resolution. I'm going to speak to the defense room primarily. I'll probably chirp in from time to time. I can't help myself. I like to chat. And then Bo's going to speak to the plaintiff's room and talk about the issues that plaintiffs and claimants typically bring to the mediation. And so I would encourage everybody to take full advantage of the questions button on the webinar here. Primarily because one of the challenges that I have, and I think Bo and I were both talking about this. This is an occasion where we're just talking. We can't really see people, or if they're not following along, or if they might have a question. Please feel free, shoot us questions. We'll try to respond to them live during the webinar, and if not, we'll get back to you afterwards. And with that, I'm going to turn it over to Bo to kind of give us some insight as to what's going on in the plaintiff's room.
Thank you, Scott. Start off with who is the plaintiff, identify the plaintiff. I think that's the basic step, so you understand the level of sophistication, the level of experience, what the plaintiff's needs are, the level of their injury, whether it's catastrophic, whether it's soft tissue, and what the needs of the plaintiff are financially. So sometimes you'll come in and the plaintiff is out of work for many months. Sometimes they aren't out of work at all. Sometimes they've got huge medical bills. Sometimes they don't. Sometimes they've got children that were injured, and sometimes they've got other issues that need to be discussed. So from the plaintiff's perspective as to what a defense should be thinking is, well, who is this person? And what are their needs so that we can actually have a full discussion on what to do. Oftentimes, the plaintiff is the least experienced person in the litigation. We take that for granted. I know when we all get together, the lawyers all seem to speak the same language. We all know how to say, liability, damages, all that type of stuff. But the plaintiff's sitting there scratching their head. They have no idea what we're talking about, but we think they do. So we have to understand that they don't have the experience and the level of sophistication that we have. So if you can break down some of the language that we're talking in terms of personalizing things and making it hit home, it's better than talking in terms of liability, causation, damages, and things like that, and collateral sources. They really don't know what we're talking about. Also, I don't know that plaintiffs often understand the costs and the risks that are associated with these cases. They don't know what it's like, for instance, to be hit with attorney's fees at some point. They don't know what it's like to go to trial and lose. They don't know what it means that if they go to trial and they win, there might be an appeal. So they need to be educated on those types of things so that while we're going through the discussion, they can get up to speed and understand the way we're thinking, what we're talking about, and the risks that are involved. Another thing plaintiffs don't understand is that you can actually get less money at a mediation and do better than if you went to trial and taking on all the risk. So having that type of a discussion with the plaintiff is often difficult because they don't know what the heck we're talking about. If they think in their mind their case has a certain value to it, they don't understand how you could substantially cut that amount today and they could do better than if they went to trial. That thought process is foreign to them. So that's something that we have to kind of talk to them about.
I don't mean to interrupt, but I find that in many of my mediations, I have to sit down, and it's surprising to me that the plaintiff's counsel sometimes doesn't do this. I have to sit down and kind of do the math with them, where I say, look, you recover this today, and you pay off your medicals, and you don't have to pay off the costs and everything associated with trial. You're actually going to net more today than you would if you got a higher number. And I just do the math, and you can literally see the light bulb go off in their head sometimes.
That's true. That's true. So it's it's important that the plaintiff, at least and from the defense perspective, that you understand that those are the type of discussions that are going on in the other room. Probably the biggest factor for any plaintiff to want to settle a case is, well, what do they put in their pocket? Oftentimes, the plaintiff sitting there, they have no idea what it means to have a gross offer, a demand, and an offer. Like, what's going on? What does that mean to me? And it's usually not until near the end that they start to realize how much they get. A lot of times, they don't even realize that the contract that they've signed with the attorney is 40% now. They'll come in and say, oh, so you're at a third and this and that, or you said it was 25% and things like that. So a lot of times the plaintiff has no idea what they're going to be putting in their pocket. And yet that's probably the biggest issue. There's also other issues the plaintiff has to understand. A lot of times they think that if they settle the case, there's some sort of separate check that goes to the doctors, to the lien holders, and to others, and that they get the amount of money they're speaking to. So you've got to understand that these people really are not sophisticated often. You have some people that are, there's no doubt about it. But you've got to take that into consideration as we go through this. So, Scott, anything you want to add about that?
Hey, Bo.
Yes.
Let me ask you this. I've found in my dealings that sometimes plaintiffs have no concept as to causation, liability, and how a verdict form works. Is that something that you walk people through, or how do you as a plaintiff's lawyer, how do you handle that?
Yeah, I do that more, probably 70-75% of the time. Again, depending on the level of sophistication of the plaintiff, also the communication between the plaintiff's lawyer and the plaintiff about those type of things. So I like to go through the verdict form with them so that we can put in front of the plaintiff what all this means, what it means in the first question about causation, what it means when we get down to medical bills, how they might be comparatively at fault, things like that. What happens if that happens, how the damages are calculated by the jury, et cetera, et cetera. So I like to do that often.
Cool.
Yeah. So the screen that just popped up is the other part that I just sort of alluded to, and that is, well, the plaintiff's sitting there thinking, if there's an amount of money being offered, that I get all that money, and all of a sudden you start breaking it down and saying, well, wait a second, you've got medical bills, you've got ongoing treatment costs. A lot of times they think that that is something that's going to be separately paid for, that there's going to be another check. A lot of times they don't understand, the connection between their loss of income and the case, things like that. A lot of times they also sit down and they haven't treated in 2 years, but they try to say, well, I need future money put to the side. They have to understand that those type of issues are going to be discussed in the other side of the room and probably lower the demand or the offer that would be given towards the demand. So those are other factors that have to be considered. So
Let me ask you this: does the plaintiff lawyer's reputation and experience come into play oftentimes?
Yeah, it depends again on the experience of the plaintiff's lawyer. You've got some very, very sophisticated plaintiff's lawyers, meaning that they try cases all the time. And you've got other people that actually don't even do personal injury. They do real estate or something else, and are doing it on the side for friends. So it's important that you kind of understand the experience of the lawyers as well. It also, as far as the presentation is concerned, I don't have to go in depth to the degree I do if it's somebody without the experience, as I would with somebody that's got a lot of trial experience, can talk to the plaintiff independently from me, and it's much easier, no doubt about it.
Yeah, and I know we're going to get to this in a little bit, but I've had occasions where a plaintiff's lawyer who doesn't do personal injury work is handling a personal injury claim with significant medicals and things of that nature, and they don't understand the ability to negotiate the medicals and things of that nature, and that can be a real obstacle if the plaintiff's lawyer is not knowledgeable on how to reduce some of the things that are coming out of the plaintiff's settlement or gross settlement. So that can be a challenge too, and it's we'll talk about that a little bit more as we get down.
Sure. But there's no doubt about it. The liens that are out there, a lot of people don't understand how to negotiate a Medicare lien or a TRICARE lien or a Medicaid lien, or these LOPs that we talk about, and we'll talk about that more, but all these different financial burdens that are on the plaintiff side once the settlement is accepted, that's a lot for a plaintiff to understand and chew on, you know?
Yep. And they're probably like you said, you know, and unfortunately, lots of times these issues aren't addressed ahead of time, and we'll talk about the importance of doing that. From the defendant's perspective, there is not, you know, you're more likely going to have a much more sophisticated person in the defendant's room, but that's not necessarily the case. Next page. You know, today, you know, there has been something that has kind of started to develop, and that is the emergence of self-insured retentions. And so, you know, one of the things that, you know, you have to kind of understand, both as a mediator and also as a participant in mediation, is who's the defendant? Is it an individual? Is it, you know, a private citizen who's not being sued for negligently operating an automobile? And is he looking at personal exposure if the case goes beyond whatever insurance he has available? Is it a company or a corporation? Are they sophisticated? Is the company or corporation present at the mediation? Are they being represented by somebody? Is there a private attorney involved? These are all important things to consider and know who's in the room. Again, you know, there are occasions where, you know, and again, it's becoming more and more self-insured people are there, and they are there sometimes with a third-party administrator. Sometimes they're not. Sometimes they're making the decisions, and they can be equally unsophisticated as a plaintiff. I've had many occasions where a company has a self-insured retention, and they're there calling the shots as to how much money should be paid. And they have no idea how much the cases are worth, what potential exposure there is, and that can be a real problem. Likewise, you have a lot of situations where in the defendant's room there are a whole group of people. It can be a you know, representative from the company. It could be the risk manager from the company. It could be the president of the company if they feel strongly about it. Oftentimes they'll bring private counsel in to kind of sit beside them and advise them as they go through the mediation. If there's a self-insured retention, there could be a third-party administrator who is also there. And then if the claim has some value that's beyond the self-insured retention, there's adjusters from the excess or the level of insurance that's beyond the self-insured retention. And you know, we all like to think, and I think oftentimes is the case, that everybody's in agreement. Everybody seems to think that, you know, we have a unified plan, and that may be what is presented in the opening, and it may be what is presented, or at least the face of that side, throughout the course of the litigation. But behind to use the analogy of the Wizard of Oz, behind the curtain, there may be a complete different thing. There may be disagreements on strategy. You know, how are we going to take and, you know, present our defense? What defenses do we think are viable? What defenses do we think should be pursued and shouldn't be pursued? There also may be, you know, disagreements as to whether or not they want to go forward. There are many occasions where the insured wants no part of seeing the inside of a courtroom, or no part of seeing the, you know, their entity, you know, plastered all across the front of the Miami Herald or, you know, Daily Business Review about a case that went to trial, and, you know, multi-million-dollar verdict came down because a restaurant was run shabbily, or because a retail establishment, you know, had negligent security. Those are all things that people who are running their business covenant. They covenant their reputation. They don't want to see the inside of a courtroom at all. But the carrier may feel, no, we have valid defenses here, and we're going to, you know, play them out, and we're going to, you know, go to trial. Those type of disputes happen all the time. Likewise, it can be the other way too. I've seen many occasions where the carrier wants very badly to limit whatever exposure they have, and they want to take and try to resolve the case, and they feel that they can resolve it for a reasonable amount. But the insured has taken a position of principle, and they feel very strongly that they do not want to have any monies paid at all. It could be for, you know, the exact reason that if they get to reputation, it's a reputational situation that's kind of flipped. If they get the reputation that they're going to pay out every time someone has an accident on their property, then you know what? They're going to have a lot more accidents on their property, and they're going to be seen as a entity that can be sued, an easy target by the plaintiff's bar. I don't know how much of that is true, but there are many businesses who feel that way, and many businesses who feel that they need to take positions of principle, and that can create a conflict within the room. Likewise, confidentiality. I've seen confidentiality is one of those issues that most businesses want to have the settlement and the terms of the settlement absolutely positively confidential. And sometimes, you know, insurance companies, that's not as big of a concern for them. And it also may be, well, you know, the insurance company can settle a case with or without confidentiality. Sometimes the plaintiff side wants to have the ability to, you know, take and, you know, talk about their settlement. It's great advertising. All of us see every day some form of advertising where lawyers are talking about the settlements or verdicts that they've obtained on behalf of their clients. Well, you know, there's a cost to that. And sometimes plaintiffs' counsels say, if you want to have it to be confidential, you're going to have to pay extra. Then you get into this conflict between the carrier and the insured as to who's paying that extra money. And sometimes it can be a pretty penny. Those sort of things, conflicts come in all the time. Other conflict is, I'm a private individual. I have a $100,000 insurance policy, and I've been involved in an accident and being sued for an accident. And, you know, I have exposure, the injuries have exposed, the liability is questionable, but the injuries have exposure well north of my 100,000. And I have an opportunity to settle the claim for within 100,000, but my carrier feels that they have great defenses and that 100 is not worth 100,000. Well, I, as a private individual, am going to be pounding on the table all day long behind the scenes for my carrier to settle, So these are some conflicts that are going on behind the scenes that necessarily don't come forth to the other side, but are there. And, you know, there are some strategies on how to handle those and how to handle them on behalf of both the carrier, on behalf of the insured, that can kind of overcome those issues and make for a successful mediation. One thing that usually is known to the plaintiff and is coverage disputes. You know, if a carrier is saying there's no insurance, and they've issued a reservation of rights letter, that typically comes forth. But you know, there are occasions where the carrier's kind of hinted at it, but hasn't necessarily, you know, done it formally. Next slide, please. And against this backdrop, you have this very unique setting of, you know, somebody, whether it's the adjuster who is representing an insurance company, whether it's a TPA, third-party administrator who is representing the insured in their self-insured retention program, is determining the amount of money to place on the claim. And it's interesting, you know, and I'm going to talk a little bit in the next slide about, who is actually calling the shots in the room. But, you know, you want to know, you know, A, who's setting the reserves, how it was determined, okay? Is it determined basically based on the facts, like most of the case? Is there any influence that the plaintiff's demand has with regard to setting the reserves? You know, sometimes plaintiff counsel feel, well, I made a policy limits demand, they should look at this as a policy limits case. And typically that's not the way the defense look at it. They try to set the reserves based upon, you know, the data that they've received through discovery, the data that they have back at the home office that takes and evaluates the type of accident involved, injuries involved. And they also, you know, factor in plaintiff's counsel and things of that nature. You know, one of the things in the mediation setting that's a little, different adjusters and different risk managers have different views. Some of them will tell the mediator, hey, this is what we evaluate the case at. We've set the reserve at X dollars. Other adjusters and risk managers want to take and hold their cards close to the vest, and they're just going to try to, negotiate as they go along, and they'll negotiate up to the number that they've set, but they're not sharing it with anyone else. They're also, one thing that I want to know is the defendant, the person who's making these decisions and setting the reserves, are they willing to ask for more? Do they have the ability that if we get close during the mediation to reach out and ask for some more authority? That's not always the case. Sometimes these cases, particularly in large claims, are round-tabled, meaning that 3 or 4 people get together, evaluate the claim, and set a number. Are they willing to go back and ask for more money? Do they have the ability to ask for more money? And is the person who makes that ultimate decision going to be available? Those are things that I like to know ahead of time. And again, all these pressures and all these interests are kind of made against a backdrop, where there's this insurance-defined relationship between the insured, the carrier, and in some cases, the risk managers who are involved in representing or acting on behalf of the insured. Next slide, please. So I'm going to talk a little bit now about some of the things that come into play as we negotiate. And those are some of we talked about who's there, some of the stuff that is influencing their decisions and influencing how they behave and what they come to the process with. Now, as we negotiate, you're going to see where the tire hits the road. Next slide, please. To me, the number one, and again, it's primarily because I do defense work in my former life, the number one thing that I think has to be addressed is what insurance coverage is there. You need to know the limits. You need to actually know, you need to know how much money there is to obtain if you have a claim, and where the value of your claim lies within the limits of insurance that there are. You also need to understand not only the limits, how much insurance there is, but is there multiple policies? It's one thing to say, oh, there's $2.5 million in insurance. Is that one policy? Is there an SIR? Is there a primary layer of insurance that has to kick in first, and then an excess that kicks in next? Because you need to understand those layers, where they end and where they start, so that you can apply pressure and leverage as the negotiations go on. Okay. You also need to understand, and this is all part of how the policies influence the negotiation process, and also influences who should be there. So by way of example, one of the things that we wanted, after we know the limits and the layers of insurance, we want to understand who should be there. Okay, who's going to be making the calls, as the negotiations go forward. Not relatively, but it's happening more and more. When I first started practicing, the concept of self-insured retention, it was there, but it wasn't invoked in issuing insurance policies as much as it is today. And I think that's because the cost of insurance has become so costly that to offset premium costs, some insurers started taking and saying, well, I'll self-insure myself for the first layer. And as I kind of went through my practice, I noticed that you would see self-insurance retentions of 50,000, and then they kind of crept up to 100,000. And now I'm kind of seeing that the cheapest self-insured retention layer that I'm seeing today is typically 250,000. That meaning that the insured, the company who's being issued the insurance policy, has to self-insure themselves, pay for the cost of litigation, pay for the claim resolution amount within that layer, okay, and using the 250,000 to layer up to 250. That's different than first dollar insurance, which is kind of traditional insurance, meaning that there's either a small deductible, and after that deductible was paid, the insurance company would pay anything that came down in the form of a settlement or a verdict. Under that situation, the insured has no skin in the game. And, there are many insurers who really, I don't care, just settle the claim. It's no skin off my back. There's no direct cost to me. And so the insurers weren't really involved as much as I'm seeing now. Now, a typical case, again, it can be a relatively small company who is carrying a $250,000 self-insured retention, meaning that they are responsible for the first $250,000 in that lawsuit. A small company, that's real exposure. That comes off their bottom line. They have skin in the game. And oftentimes, they are now engaged. They're not only showing up at the mediation, but they're calling the shots at the mediation. And it's also my experience that a lot of these insureds who are under self-insured retention programs are actually, deciding who the TPA is, who the third-party administrator is, who's going to be administering their self-insured retention. And why is that important? Well, if that TPA wants to continue the relationship with that insured, he's going to do what that insured wants. Excuse me. And I can't tell you how many times I've had insureds come in and dictate to the TPA what the negotiation strategy is going to be. And that can cause some problems, as I alluded to a little bit earlier on, in the sense that, if you have an insured who's in the business of making widgets, calling and making risk management decisions, it oftentimes is skewed and not realistic and makes for a challenging mediation. And that's a pressure that is very, I would say, is increasingly becoming more and more problematic. Next slide, please. We talked about understanding the layers of insurance and what I would call a breakpoint. A breakpoint, and I don't know if that's the proper term, it's what I call it, is oftentimes where the first layer of insurance ends and the next layer begins. And if we can go to the next slide, there's something in there that I want a diagram that I want to show. This is, let's just say, this is a illustrative of a tower of insurance. Then the total insurance available here would be $2.25 million, $2,250,000. And the first layer of insurance is the $250,000 layer, and that's the SIR. That's the self-insured retention that I've been talking about, and some of the challenges that it presents. The break point there is at the $250,000 layer, and that next goes up into the excess, or some would call it a primary, but it's excess of the SIR, and so that's a million. And then beyond the first million, beyond the 1.25 in total dollars, is the second million, to make a total of $2.25 million in available insurance. Now, under this program, let's just assume that there's a claim that is pending against this program, and at the beginning of the litigation, the policy limits demand is made, and then that demand is not changed. The case has, let's just assume that the case has exposure beyond 2.25 million. Okay, just in theory, but not likely. But let's just say there is potential for the exposure to be north of that. And however, plaintiff's counsel has the ability to shut the case down for 1.25 or 1.5 million. Okay, plaintiff's counsel is going to want to have everybody there. Okay, all of these people. You're obviously going to want to have the people who are administering or controlling the SIR. You're going to want to have the adjuster for insurance company A, the excess layer, and then the umbrella layer. You're going to want them available. And the reason is because, number one, you're required to have all these people there, and defendants required to have all these people there, unless otherwise excused, because that's what the plaintiff's demand is. You have to have authority for the plaintiff's demand. If they've demanded policy limits, everyone needs to be there. Secondly, unless the plaintiff's lawyer agrees to excuse somebody, everybody should be there. Nothing sours a mediation more than a defendant's determination, well, you know what, this case is never going to go into the second $1 million layer, so I didn't bother to have him come. That sets a very bad tone within the mediation and creates all sorts of problems from the word go. But I would say the third reason you want everybody there is probably the most important. It's the opportunity to have some leverage. If you're the plaintiff's attorney, you can, as the negotiations go on, you can say, look, I'm through negotiating, $10,000, $50,000 at a time. You either tender the SIR to the next layer of insurance, or we're leaving. And if the case is truly worth what you think it is, that will probably happen. Once that occurs, the adjuster or representative for insurance company, the excess carrier, they now are taking over the negotiation. And obviously they're going to want to take and try to settle it for as low as possible. But you know who else is going to want to have that case settle at that layer? The umbrella, the next layer of insurance. They're going to be looking down to the excess layer and saying, excess A, you need to settle this claim within your money because I don't want to spend any of my money. That helps the plaintiff's counsel because they're not the only ones telling excess A to settle, but so is the umbrella above it. So these are reasons why you want to make sure that everybody's there. Let's go back to the slide before, please. The other thing, if there's an insurance dispute, let's say that the carrier is taking a position, hey, we don't provide coverage for this type of incident. We're not going to have anything here. Who do you think we were going to want to have at that mediation besides the insurance company? We're going to want to have the insured, who's now bare, has no insurance. We want to hear what they have to say about that position. But more importantly, we're going to want to encourage the insured to have a private counsel there, because private counsel will take and have the ability to, possibly point out some things to the insurer that they didn't realize that might have, at the end of the day, afford coverage, and also encourage everybody to take and try to resolve this at mediation, as opposed to going through the whole expense, delay, and issues that arise in a debt relief action where there's trying to see if there is or is not insurance coverage, or possibly miss out on the ability to settle at mediation for a lot cheaper than you would if the issue of coverage was not in dispute. So there's, in that setting, you're going to want to have the insured and their private counsel there present to kind of help address those issues. So it's important to make sure next slide, you really understand as you go through this how coverage affects and the amounts of insurance affect what's going on in the defendant's room, because as we go further, you'll see there are reasons why it helps out. Bo, can you talk about negotiating liens and medical bills?
Absolutely. So one of the hardest things for plaintiffs to accept a settlement is wondering what they're going to put in their pocket. So from the gross settlement, as we discussed earlier, the medical bills, the liens, and the other responsibilities get taken out of that amount. And there's numerous types. Of course, a lot of them are negotiated differently, or there's a basis for recovery, like statutory versus contractual and so forth. So for instance, if you've got Medicare or Medicaid and you settle the case, well, as soon as you do that, you're going to have to negotiate with those entities for the settlement. Now, the problem is the plaintiff's been asked to accept the settlement at the mediation without knowledge as to what they're going to get. So there's an estimate is usually made to do that. Then you've got LOPs, which even now, as we go through each mediation each time, I'll hear, well, you're going to have to, under the new statute, reduce your meds to the jury by this amount. Well, the problem is, as we sit here today, there's limited case law. There's judges doing different things in different jurisdictions. There's really no appellate decisions being made. So the defense will say, you're going to have to do that. And the plaintiff say, no, I'm not. And they'll be into that little back and forth. The plaintiff will believe that he can present to the jury the totality of the LOP or the totality of the medical bills. And on the other side, defense is going to believe that, no, that's never going to happen, but we don't know the answer. So that makes it very difficult for the plaintiff to make a decision. Then we have some other things like hospital liens. Hospital liens are very difficult to negotiate, especially if it's a recorded hospital lien. They're not going to just say, okay, we're going to take a reduction, a substantial reduction on that bill. You're going to have to contact the hospital. You're going to have to get somebody there to negotiate with you. That takes time. And a lot of times they're not willing to negotiate down to the level that you want. We've got military liens, TRICARE, things like that, that have to be discussed, because if TRICARE isn't going to reduce the lien and your client wants a certain amount of money in their pocket that you can't guarantee, how in the world can you settle that case? You can't. So all these things are out there. And then last, we've got another potential problem, that is loans that people take out on their cases. These loans can be extraordinary. And again, depending on the relationship between the law firm and the company that's actually giving the lien out or the loan out, there's another negotiation that has to occur. And sometimes it's very difficult to get them to reduce to a level that the settlement, the net settlement to the plaintiff, is worth it. So all these things need to be addressed as early as possible. The other problem, though, is sometimes the people that you're negotiating with want to know what you get or have an idea what the gross settlement is. But if you don't have a gross settlement and they want it and they don't want to negotiate with you, it can lead to some issues there as well. So these are some of the other major concerns that the plaintiffs have when we're going through the process of settlement.
Okay.
One thing I did want to bring up, and Scott, you do have a slide there, that one of the things I hear all the time is, well, the plaintiff's providers are going to take 20 cents on the dollar, 30 cents on the dollar, and that it's an automatic thing. Well, it's not. And especially now with the new statute that's out with regard to medical liens and bills and LOPs and what's presentable.
Next slide.
Some doctors are not willing to negotiate and it's the medical providers that they've got people that work there that do the billing. They've got board of directors. They've got all kinds of things that are going on that you have to negotiate with. And, until they know what you're getting, a lot of times they don't want to do it. And second, with these new statutes that are out there, no one really knows what is presentable to a jury. So these doctors are, not as willing to, a lot of times, sometimes they are, but are not as willing to negotiate prior to trial like they would be before. So, maybe you have to go get equitable distribution. You have to do things like that, which damages a relationship, but at least you can predict what a plaintiff's going to put in their pocket. So these are difficulties that go on in a plaintiff's room during the negotiation and during the mediation.
Yeah, I've had one plaintiff's counsel put to me that that the providers that normally are a little more willing to negotiate the amount of monies that they are owed, the negotiations have become a lot more difficult because the providers are seeing that the new statute is going to make their business model much more difficult, and so they're getting as much water as they can, so to speak, before their well runs dry. So it's proposing some challenges in the mediation setting.
No doubt about it. No doubt about it.
Hey, Bo, are legal financing, are those folks willing to negotiate, or or how does that affect things?
Well, it depends. First off, the viability of the company. If you got a good, stable company that does business all the time, is willing to call you and talk to you and negotiate, fantastic. But if you have a startup company, or you got some company that's trying something a little different, their security, they're nervous, it gets more difficult. But if you have a company that has been getting liens or loans to your clients for a while and you're familiar with them, and then it's not as big a problem. But if you've got some California company that you've never dealt with before that is not as stable or doesn't know you or feels insecure, then it gets very difficult.
Yeah, and I imagine they want to know what the gross settlement's going to be too before they
Absolutely.
take any skin off it. Yeah.
Absolutely, yeah. They get a percentage of the gross, so a lot of times.
Right.
So,
All right, next slide. So look, as you can see, a lot of these issues create situations where there's different assumptions in different rooms, leading to different pressures in different rooms. Again, the negotiable, medical bills and treatments that are negotiable, the assumption on the defense that, oh, this will, the doctors will take 20 cents on the dollar, oftentimes isn't a reality. And, or, there may be problematic, providers that aren't willing to negotiate at all, such as hospitals, or even some providers who don't do this type of work can't understand why they would ever, compromise their bill. And so, it's important to understand the pressures in each room so that if there is some collaborative ways to kind of work around the pressures, that we do it. And that's one of the roles as a mediator, that, as mediators, we try to find some common ground or some common way to overcome a problem that one party may or may not be having. Next slide, please. And actually, let's go to the slide after this. Sorry about that. And look, this is kind of something that many of you have attended any mediation seminars before. You hear this stuff about how collaborative approaches are necessary. And the fact of the matter is, it really is important that you enter into a mediation, particularly with all these different issues, particularly with all these different pressures, and kind of look for mutual gains where possible. Try to avoid taking positions, but, really looking for what each party's interest is, and to see whether or not you can understand the interest and make, a resolution. And, you want to try to, in your mind, and also the party should think this way too, generate as many possibilities of deciding what to do. And you've probably heard this analogy before, but it's much like solving an argument over an orange. If two people want the same orange, if you take positional approach, one's going to say it's my orange, or I found the orange, or I saw it first. Those are positional approaches. That's not going to solve anything. But if you kind of look beneath the position and look to the interest, why does one person want the orange and why does the other person want the orange? Oftentimes you can find a resolution. So for example, if one person wants the orange to eat it, and the other person wants the orange to use the peel in cooking, well then, you know what? There's no real dispute. You just peel the orange, give the peel to one guy, and let the other guy eat the orange. That's the kind of mindset you got to have in kind of looking at these issues and how they affect in the mediation process. Let's go back the slide, please. And in order to do that, it takes a little bit of footwork that starts before the mediation. I had a law professor when I was in law school way back when kind of tell me about it for planning for trial, the 5 Ps, which stood for prior, preparation, prevents poor performance. And I think that applies equally, if not even more so, to mediation. In mediation, both parties got to understand the damages ahead of time. You got to make sure that all the damages are on the table. I cannot tell you, Bo, I don't know if you have this experience, where the defendant comes in thinking, well, there's $150,000 in medical bills, and then suddenly the plaintiff shows up with over $300,000 in medical bills.
Boss will take a bucket of water and throw it on the process.
Yeah, it just completely shuts it down. And likewise, insurance coverage, understanding insurance coverage. It amazes me how many times a plaintiff will come to the mediation not having any idea how much insurance is out there. And I don't understand how you can, negotiate a claim if you don't know how much there is to negotiate for. And I've even had situations where the defendants don't understand the insurance coverage or the tower of insurance, and they don't have the right people there. And to use Bo's statement, that, kind of creates, you're throwing water on the process right there when, you don't have all the decision makers there, And as Bo pointed out, you need to know what liens are out there and which ones may or may not be able to be compromised. And so it takes a little bit of footwork. Likewise, and Bo can probably speak to, managing the plaintiff's expectations better, but you got to understand the client's concerns, pressures, and desired outcomes. And then you have to manage their expectations. So, I highly recommend meeting with the client well in advance of the mediation. So many times, and Bo, you might be able to speak to this, I see plaintiffs coming in thinking that, and it still to this day rings true that I hear examples, well, that lady got burned at McDonald's and recovered 14 million. How come I'm only being offered 50,000? And so, you got to start managing the expectations.
Well, I think a lot of plaintiffs don't know where the number comes from. And I think if you sit them down and show them where the breakdown on the verdict form is before mediation, show them, you know, what the medical bills are, what the future meds are, what the loss of income or capacity for loss of income is, explain to them, especially in automobile cases, the permanency question, and then also explain to them that there's no set number for pain and suffering if they get there, that's something that every jury is going to do differently. So you just can't predict it. So it's not as easy as, hey, I saw something on TV, or my neighbor got this, or I saw that the McDonald's coffee case, the guy got 14 million. I mean, they need to be shown how these damages are calculated, and I think that's important.
Yeah. And it's equally as important to the unsophisticated defendant. You know, oftentimes they don't appreciate what juries can return, particularly, you know, in the pain and suffering realm. They just have no concept. And, you know, I had in my private practice, I represented a self-insured, and it was a very wealthy gentleman who was involved in a boating accident, and the boating accident resulted in a very significant injury to somebody, and he just on his own paid for the medical and sent the plaintiff you know, a room full of flowers, and thought that that was the end of it, and why should I be required to do more? And I had to spend probably an entire day managing the fact that that's not enough. And it was surprising to me how difficult it was to get him to see the exposure and the value. But it was imperative. And we ended up settling that case prior to mediation because of the work that was put in ahead of time. I think after meeting with your client, I really encourage people to reach out to opposing counsel and try to kind of manage expectations, or at least talk about some anticipated obstacles that you may know about that are on your side of the case. And just kind of, you know, work together to see if you can kind of set the mediation up for a level of success. And, you know, it's not just managing expectations about issues, but also managing expectations about, you know, necessarily what you're going to, you know, what your client wants you to demand. You know, this happens frequently that, you know, there will be a demand prior to the mediation of 500,000. And then after openings, the plaintiff's new demand with nothing else changing is now 1 million. And that is a real problem, because the defense, you know, they may be able to get $1 million in authority, but they have to roundtable it and meet with a committee to get that type of money ahead of time. And if, you know, the desire for that type of authority being present at the mediation isn't conveyed ahead of time, then it's going to be a short mediation with a lot of irritated and angry people. So, you know, I really encourage people to speak out ahead of, you know, speak with opposing counsel ahead of time to the extent that they can.
I think that's great. A great idea, Scotty. No doubt about it. No doubt.
Yeah, and last but not least, I know Bo does it, I do it. I try to touch base with the counsel before each mediation so that they can inform me about sometimes issues and obstacles that they may see. It allows me to be prepared to kind of, you know, address certain things that may require a little bit more thought, or, you know, maybe I reach out to their side and kind of discuss issues and, you know, kind of, again, prepare for the mediation. Next slide. All right, so, you know, look, and I think, you know, we're kind of getting towards the end. You know, I think the one thing that I, you know, want to encourage people to kind of look at, I've had a couple experiences in my mediation practice. I had one that was kind of interesting. We had a woman who could not make a decision as a plaintiff without her spiritual advisor being present. And, you know, the confidentiality rules make it such that she couldn't bring it in, and she got to the mediation, and it was just no decision could be made for anything. And so after talking with the defendants, we decided we're going to waive confidentiality. And suddenly I got it, we waited a half hour, the spiritual advisor was there. And we solved the problem by just kind of talking across the divide and making things happen. That's an easy one. I also had a case where, again, going to LOPs, where we had a accident in South Florida, but the majority of the medical treatment was out in Utah. When it came to waiving the bills, the Utah providers had no desire to participate, not waiving, but reducing. And, we're at an impasse, and, defense counsel couldn't understand it. And I was allowed to share that problem with him. He suggested that why don't we arrive at a number, and I will give all my work product that my billing expert developed and actually turn my billing expert loose on those providers to negotiate down the bills. And guess what? They did. And then we came back again and settled the case. So those are examples of people understanding the pressures and the issues and reaching across to work for a collaborative resolution.
The last thing I've got to say is there's this legend out on the street that, especially from the defense side to the plaintiff, that if you're negotiating, start very low, because they're going to teach the plaintiff some sort of lesson that they're going to get. If you say, okay, they're at $1 million, so we're going to start at 2,500, but you have a reserve of much greater than that, the plaintiff doesn't get it. So if you say it's 2,500, all it does is aggravate the situation. And I can tell you that on multiple occasions, hours after the mediation, the real money came out and the case got settled. So my thought is to encourage everyone to, if you've got it, encourage your adjusters to put the money out there, make the process roll, give the plaintiff something to think about. Don't make a decision for the plaintiff's lawyer to say, no, we're not going to settle this case because you're not at a certain dollar amount. Make it hard for the plaintiff's counsel to do that by putting the money on the table and giving the plaintiff the decision-making process. And that's all I've got to say.
Right. So listen, we're chatted probably a little too long. If anyone has any questions, feel free to put them in the question box. But we're pretty much at the end. I think there's a slide at the end that Kathy can speak to that has my contact information and Bo's contact information. We had a good turnout today. I want to really thank everybody for coming out.
Thanks, everybody. And again, the whole theme today was, by looking in the other room, we create an opportunity to settle the case. So think like what's going on in the other room is a good philosophy. And thanks, everybody.
Thank you.
If you're a Florida attorney, please jot down the Florida Bar course number so that you can post your CLE credit online. It is 2310946N. Again, 2310946N as in Nancy. We're building our webinar schedule for 2024, so please watch your email inbox for news about our future programs. And on this slide, you're going to see contact information for our presenters and technical assistants. And thanks, Scott and Bo, for a great program.
Thank you, Kathy.
Thank you for everything.